Good day, dear learners. This is Karthik Shiva, Assistant Professor of Law at VIT School of Law. I will be discussing a new module with all of you. The module is Union Government. The Union Government comprises of three wings, that is the legislature, the executive and the judiciary. The legislature is that part of the government that is concerned with the making of laws. On the other hand, you have the executive, which is concerned with the execution of laws. And the third wing of the union government is the union judiciary, which is vested with the responsibility of interpreting the laws. First things first, we will take up the union executive. The provisions for the union executive begin from Article 52 and goes on up to Article 78. As we already discussed, the union executive is comprising of primarily the president at the top. After that, you have the vice president. Along with that, you have the council of ministers headed by the prime minister. And last but not the least, you have the attorney general. So this is essentially the composition of the union executive. When we speak of the union executive in India, it is twofold in nature. On one hand, you have the nominal executive comprising of the president, who is the nominal head of the state, on whom the powers are vested as per the constitution, who enjoys powers as per the letter of the constitution. On the other hand, you have the real executive comprising of the council of ministers headed by the prime minister, who is in turn the real executive, who actually wields the power in consonance with the council of ministers, who are democratically elected by the people. So thus you can see that there is a dual executive comprising of nominal headed by the president, who is the head of the state. On the other hand, you have the real executive, which is run by the prime minister and the council of ministers. This continues not only at the union level, parallelly you have the same structure repeating itself at the state level, wherein the nominal executive is the governor and the real executive is the chief minister and the council of ministers who assist him in the states. So this is the structure which we will be following. We will be first discussing the position of the president, his role, his power, his functions, what are his qualifications and conditions of office. After that, we will be taking up the position of the council of ministers and the prime minister. Following this, we will be discussing the union legislature, which comprises of the Lok Sabha and the Rajya Sabha. What are the conditions, what are the requirements, what are the powers, what are the qualifications to become a member of the Lok Sabha and the Rajya Sabha? What powers do these houses of parliament enjoy? We will be discussing that. Last but not the least, we will be discussing about the union judiciary comprising of the Supreme Court. How are the Supreme Court judges appointed? What are their powers? What are their functions? What is the jurisdiction? And what is the role and relevance of the Supreme Court in India's constitutional framework? This is what we will be essentially discussing. So now moving ahead, we will come back to our discussion on the classification or the broad nature of India's union executive. So to repeat my point, as I already said, the union executive comprises of, once again, the president, the vice president, the prime minister, the council of ministers, and finally the attorney general of India, who is the topmost law officer of the nation. Article 52 is the first and foremost article which we will be discussing when we speak of the position of the president. Article 52 to 62 of the Indian Constitution deals with the position, powers, function, and the way in which the president is appointed or elected. So as I already said, India is a democratic republic and not a constitutional monarchy. That means that the head of the state is elected democratically. We are having the current president, Srimati Draupadi Murmu, who is the 15th president of India. How is she elected? The process for election of members or the position of the president is distinct from other elections. The president is elected by what you call as the Electoral College of India. It is a system of indirect election. The indirect election comprises of the Electoral College, which encompasses both the elected members of the state legislative assembly as well as the elected members of the parliament. Apart from this, it is important to note that the term of office of the president, it is for a period of 5 years. There is no bar on re-election. So a person can hold the office of the president how much ever times he intends to do so, so long as he is elected or chosen. More importantly, coming to what is the function of the president. Essentially, we all know that the President of India succeeded the King of India, that was King George VI, who was the ruler of India after the Indian Independence Act of 1947 came into the picture. So, the British sovereign came to be replaced by a democratically elected head of the state, that is the president. But when you look at the functioning of the President of India, it is quite different from the British monarch. Of course, it is ceremonial, of course, it is nominal, but a lot of powers and functions are vested in the hands of the president. When you look at the President of India, we can say that it is akin to the position of the President of Ireland, wherein also he is elected, but he is bound by the aid and advice of the Council of Ministers. So India, the president, Indian president, is not able to or cannot act independently of his own wish, whims and fancies. He is expected to act as per the aid and advice that is rendered to him by the Council of Ministers. So when you compare and contrast the position of the Indian president with that of the British crown or the monarch, we can find a reference to this concept in Dr. B.R. Ambedkar's statement that he made in the Constituent Assembly. I quote, he says, under the draft constitution, the president occupies the same position as the king under the English constitution. He says he is the head of the state but not the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. His place in the administration is that of a ceremonial device on a seal by which the nation's decisions are made known. So the function of the president, as envisaged by the constitutional framers, was quite ceremonial. Notwithstanding this fact, the President of India has a lot of prestige and importance associated with it. So what are the various articles that lay down the composition, election as well as the powers and function of the president? Article 52 to 62 deals with the position of the president. How is he elected? What is his qualification? What is his term or tenure of office? As well as the impeachment of the president is dealt in these articles. First and foremost, we have Article 52, which talks about the office of the president. It says there shall be a president of India. That means that the office of the president of India is created by this article, and that at all times there shall always be a president who will serve as the head of the state. The next article, Article 53, deals with the executive power of the union. That is, what executive power does the union possess? As we already discussed, executive power is the power to execute the laws as well as other aspects of the law. When we look at this, what is the executive power of the union and who enjoys the executive power of the union? It is very clear that the entire executive power of the union is vested in the hands of the president. So the president is the sole repository of executive power in India in relation to the union. So what is the extent of this executive power? We have reference to Article 73. Then coming to the matter of election. As we already discussed, election to the office of the president is by a manner of indirect election. That is, people like you and me do not elect directly the president as in the case of United States of America, but rather it is our elected representatives, that is the members of the parliament and the members of the state legislative assemblies whom we have voted for. They choose who is going to become the president through an election that is conducted through a modality known as the Electoral College. So as we've already discussed, the Electoral College, as under Article 54 of the Indian Constitution, comprises of the elected members of the state legislative assemblies, including the Union Territory of Delhi and Puducherry. Apart from that, the elected members of the two houses of the parliament, that is the Lok Sabha and the Rajya Sabha. So put together, this forms the Electoral College, which is given the power and the privilege of electing the president. So when we look at the manner of election of the president, the manner of election as under Article 55 of the Constitution of India, it says it is through what you call as a system of proportional representation coupled with single transferable vote. Because you and I do not get a chance to vote in presidential election, there is a unique system that is devised under Article 55 in order to ensure that all the states and all the people of India, through their legislative assembly members and through their members of parliament, are getting an equal say in the voting of the president. So this is Article 55, which talks about the manner of election of the president, which is an indirect election, that is single transferable vote coupled with proportional representation. Then comes the question of term of office of the president. As we've already discussed, the tenure or term of office of the president goes on to 5 years. A person who is elected stays in office for a time frame of 5 years. And then you have Article 57, which makes it possible for a person to be re-elected to the position of president. That is, there is no bar on re-election. Unlike the US Constitution, which caps and limits a person from continuing in office beyond 2 terms. That is, no person can become a president of the United States of America for a tenure of more than 2 terms. In India, that is not the case. A person can continue in office for how much ever terms that he wants, and there is no legal bar. As a side note, I can tell you that the longest serving Indian president is Shri Rajendra Prasad, who served as the President of India for almost around 12 years during his tenure. The next question that comes to our mind is, what are the qualifications to become the president? Who can become the president? This question is answered in Article 58 of the Constitution, which talks about the qualification for the election as president. The first and foremost condition is that he should be a citizen of India. Herein also there is a distinction that you see. In India, a person who is a citizen, irrespective of whether he is natural born, naturalized, or a registered citizen who was born in a foreign country, each and every person is eligible to hold high constitutional offices, including the President of India. So it means that you need not necessarily have been born in India to be eligible to become the President of India. On the other hand, when we look at the United States of America, there is a precondition that only natural born citizens, if your birth has taken place in USA and you are a US citizen, and only then can you become the President of USA. But that is not the case in India. You need to be a citizen first and foremost. The second condition is that you should have completed at least 35 years of age. That is the minimum eligibility criteria in terms of age limit for you to become the president. The third point is pertaining to the qualification of that of a member of the Lok Sabha. That is, a person who intends to become a president, he has to fulfill the conditions that are laid down for a member of the Lok Sabha. You have to fulfill the same criteria. Apart from this, you are not supposed to hold any office of profit. That is, there should not be any other position that you hold which creates a conflict of interest with your position as the president. So that is the concept of office of profit. So if you are a citizen of India, if you are over 35 years of age and you have the qualification to become a member of the Lok Sabha and you do not possess any office of profit, then you are eligible or you are qualified to contest in elections for the position of the president. This is Article 58. Then you have Article 59, which says that a person who is a member of the Legislative Assembly or the member of the Lok Sabha or the Rajya Sabha rather is not permitted to become, or he is not simultaneously allowed to stay as the president. So the moment a person becomes the president or is elected as the president, then he loses his post as a member of the Lok Sabha or the Rajya Sabha. Same is the case for not having any office of profit. So along with the presidential position, various allowances, salaries, emoluments and benefits are conferred upon the person who is holding the post of the president, and he is entitled to enjoy all these perks and benefits in accordance with Article 59. Then comes Article 60, which talks about the oath or affirmation of the president. This is also a very important provision of the Constitution, which speaks of the role and function of the president. The role and function of the president is categorically reiterated in the oath, which says that I, so and so, which is the president, shall preserve, protect and defend the Constitution of India. That is, the duty to protect, preserve and defend the Constitution of India, that vests in the hands of the president. So this is singularly important. So we can say that the president along with the judiciary serve as guardians of the Constitution. So it is his responsibility, it is his mandate and it is his requirement that he ensure compliance with constitutional principle as a defender of the Constitution. Article 61 is the next article which deals with the concept of impeachment. Impeachment is an extraordinary measure wherein which there is a power that is vested in the hands of the Union Parliament comprising of the Lok Sabha and the Rajya Sabha, the House of the People and the Council of States, to remove a person for certain reasons from the position of the president. This removal of the president in constitutional terms as per Article 61 is termed as impeachment. We will be discussing the concept of impeachment and the procedural requirements in our subsequent parts. The next is Article 62, which talks of time of holding of elections for the post of president. It requires that the Election Commission of India, which is the body that is entrusted with holding all elections in India, including presidential election, conduct the election for the post of the president in a time-bound manner without any delay, right? So before the completion of the 5-year time period that we saw, a person, the new president has to be elected or re-elected as the case may be. So this is a constitutional mandate in accordance with Article 62. Now, coming to the discussion on the president and what happens if the president is unable to fulfill his duties or discharge his functions. This is an interesting question that the Constitution answers. If you may recall, we saw in Article 52 that there shall be a President of India. It means that in all circumstances, all situations, necessarily the office of the president must be filled. So it means that if a person is unable to fulfill or is unable to discharge his duties as the president due to death, resignation or any other reason, there will be a person who will be serving as a stand-in. The person is referred to as acting president. Under our constitutional scheme, Article 65 gives us the answer for this question. It tells us that the Vice President of India will serve as the stand-in or acting president whenever the president is unable to fulfill his functions. Now, a question may come to our minds: what happens if the Vice President is also unable to discharge his function? The answer once again lies in terms of Article 70, which confers power upon the Parliament to make law to fulfill or to cover any other contingency or exigency which is not provided for. So in accordance with Article 70, the Parliament has enacted a separate enactment known as the President Discharge of Functions Act of 1969. In accordance with the President Discharge of Functions Act of 1969, Section 3, when the Vice President is also not able to fill the shoes of the President, then the mantle falls over to the head of the judiciary in India, that is the Chief Justice. So the Chief Justice of India will take over the functions of the acting President if the Vice President is also unable to fulfill this condition. So this has happened once in India's constitutional history, when former Chief Justice of India, Shri Muhammad Hidayatullah, he was appointed, or he served as an acting president in the absence of Shri V.V. Giri, who resigned his office as acting president to contest in the next presidential elections. So this was one instance wherein the Chief Justice of India, who is the topmost judicial officer of the nation, also adorned the post of acting president. One more interesting side note is that Shri Muhammad Hidayatullah is the only person who has the distinction of having served 3 important constitutional posts during his lifetime, that of the Chief Justice of India, that of an acting president, and subsequently after his retirement as that of the Vice President of India. So he has this distinction of serving 3 constitutional offices, which is second to none.